Hey guys, welcome to part 7 of our series where we're going through the text of the FDCPA. And today we will continue and actually finish section 1692E, which is false or misleading representations. If you haven't seen the previous videos, there are 6 previous videos where we go through starting at the beginning of the statute up through where we are now. You can find those on our channel, and they're labeled Part 1 through Part 6 of the FDCPA. Okay, so before we dive into these examples, remember the general rule, 1692E, is if a debt collector does anything deceptive or misleading, then they have violated the law. And these are merely examples or illustrations. So number 7 is if there's some representation, implication, suggestion that you as a consumer have committed a crime or you've done some type of conduct which will be disgraceful to you. And if that's not true, in other words, what they say about committing a crime or doing something disgraceful is false, then they violated this law. Now, if it's true, then that's not going to violate this law. Number 8 is a big one. We use this a lot in suing debt collectors. And I remember when we started doing this many years ago, and even frankly as recently as this year, I've had major companies tell us that even though they do false credit reporting, there's nothing in the FDCPA that prevents that, which is just an absurd position. And we know that because we go back to E, just the beginning part of E. It says if you do anything deceptive, well, if you're putting false information on my credit report, that's deceptive. That's anything, okay? But then we have this subsection 8, communicating or threatening to communicate to any person credit information which is known or which should be known to be false. Okay, let's just stop there and we'll pick up the last part in a second. So if the debt collector is doing something that's false and they know it or they should know it, then that's a violation of this statute. So if a debt collector let me give you a sort of classic example, is I owe $5,000 to Portfolio Recovery, or at least they say I do. I settle with them and pay them $3,000. And then they update my credit report to show that I owe $2,000. Well, wait a minute. If we settled, I owe them $0. Now, they might put in their settle for less than full amount. That's fine. But the balance that I currently owe them is $0. There's nothing that I owe them. Okay? If we went up to them and swore them in and put them in federal court and the judge said, tell me exactly how much John Watts owes you, they would say, well, he owes us nothing. So my credit report should show $0. So they know that because they settled it. They took the check. They made the settlement offer, whatever it is. So if they know it, then definitely a violation. If they should know it, okay, so they could look at their records, or you've given them information that a reasonable company would say, okay, well, this guy does not owe this debt. Well, then that would violate this if they continue to report it. And look at this last part, including the failure to communicate that a disputed debt is disputed. So if you do a dispute letter, some people call it a validation letter, verification letter, but just in general we call it a dispute letter, where you're saying to the debt collector, or you do this verbally, I dispute this debt. Okay. Now a lot of times I'll try and talk you out of that and say, well, now are you saying you dispute this because I'm going to have to write you down as a refusal to pay? Okay. Well, first of all, you have every right to dispute a debt with the debt collector. Okay, you don't have to give them reasons. If you have reasons, that's great, but you can also just generally say, I dispute owing this debt. And then when they update your credit report, they better mark it down as being disputed, or that's a lawsuit. Now, years ago, we were probably suing 5, 6, 7 debt collectors a month for doing this. And then they kind of wised up because they were being sued so much, and they generally will make your credit report accurate in the sense that they'll mark it down as disputed. But let's go to another example. Let's say Midland Funding sues you and you beat them at trial. Okay, the judge says you do not owe them this money. Well, what if the next month they still have you down as owing them a debt. And then the next month, they say, you owe this debt. Well, they might say in their minds, well, we truly believe you owe it. So it doesn't matter because the judge said you don't owe it. So they know it, or they should know it to be false. So that would be a violation. Let's look at section 9 here. This is basically saying if they're giving you something in writing that looks like or is too similar to some kind of agency, like imagine, you get something that has IRS written across the top, and really that's some acronym for, Internal Revenue Selection Collection Agency. They call themselves the IRS. Well, they're trying to simulate or falsely represent to you that you're dealing with the IRS, not with the debt collector. We don't really see this very often. It'd be pretty rare for that to happen. Now, number 10, we use this all the time. In a sense, it's really just repeating what the general rule is. But notice this will apply to basically any of these other illustrations. Number 10 says the use of any false representation or deceptive means to collect or attempt to collect any debt or to obtain information concerning a consumer. So they are trying to collect the debt and you don't pay it, and you sue them because they lied and they go, well, it didn't work. We didn't actually collect the debt. It doesn't matter because they attempted to collect the debt. Or they're lying to your neighbors. They're lying to your family members to get information about you. Then they may have run afoul of this law and can get sued, this subsection 10. So let's look at 11. This is kind of lengthy, so I made it a little bit bigger, but it also is kind of a unique thing here because you wouldn't necessarily get this from just reading the general section 1692E. And I'm going to read this in two ways. Hopefully it'll make sense. The failure to disclose in the initial written communication with the consumer that the debt collector is attempting to collect a debt and that any information obtained will be used for that purpose. So they have to do that. But what if the initial communication is verbal? Then it says the same thing. They have to tell you they're trying to collect a debt, any information be used for that purpose. A lot of times this is called the mini Miranda, like the Miranda rights you see on cop shows. You have the right to remain silent. Anything you say can and will be used again. This is like the miniature version of that for debt collectors. So that if you're dealing with a debt collector, you're warned at the beginning, hey, this is a debt collector. They're trying to collect the debt. Any information obtained will be used for that purpose. So we've sued debt collectors before. They'll call you and say, hey, I've got great news. This is Bob Smith from such and such law firm, and your great uncle, slash cousin 5 times removed died, and you're the only living heir. And he's got $1 million. I need to get that to you. And I just need to get some information from you. Well, obviously, if that voicemail is left for you and you don't know that's a debt collector, you may be tempted to call him back because, it could be true. Probably not, but it could be true. But this is saying to debt collector, no, you better warn people that you're a debt collector. So if you're leaving them a voicemail, you got to leave a message that, hey, I'm a debt collector. Now, we used to sue all the time for this because the voicemail messages would not have that disclaimer. And they would say, but what if we leave it and a third party hears it? Then we'd be sued for that. You know what the simple answer is? Then don't leave a voicemail. You have no constitutional right, no God-given right to leave a voicemail. If you leave a voicemail, you may get sued. Now, one way that they try to work around this is say, hey, this is a message for John Watts. If you are not John Watts, stop listening now. If you are John Watts and anybody can hear, make sure you make it so they can't hear this. Pick up the phone or stop the message. I'm going to give you a 10-second pause to arrange things. And then they go forward with it. And look, that's somewhat legitimate, depending on how they do it, what they know about your situation. But the point is, when you first hear from a debt collector, they should give you this mini Miranda. And then in all subsequent conversations or communications, they need to say, hey, we're from a debt collector. This is a communication from a debt collector. Now, this last part was added to say this does not mean a lawsuit is a communication. And so they don't have to put this on lawsuits. Now, a lot of collection law firms will still go ahead and do that, either out of habit or just to be safe. All right, then we have these other ones we can run through pretty quick. They're just not very common. Number 12 is the idea that, hey, we bought this and we're innocent purchasers for value. There's sort of a concept in the law, whether you're buying property or buying a car or some other type of good, that if you are a bona fide purchaser or an innocent purchaser for value, that you get some protection there. So it's sort of don't take this literally, but there's some truth to what I'm about to say just to illustrate this. If I loan you $100,000 and say I'm going to take out a mortgage on your house, I'm going to put a mortgage in the probate court, but I fail to do that, and then you sell that property to Jack Smith, and he checks probate records and it looks like the property's free and clear, well then I can't come back to him and say, wait a minute, I've got the lien on that property, because he's a bona fide purchaser. He bought it. He was innocent. He relied on the probate court, and that's on me for not filing the deed. Okay. Now, a little more to it than that, but hopefully that illustrates the point. If the debt collector is saying to you, well, hey, we're Midland Funding, and since we bought this, you have no defense to us, because we paid good money for this, so I don't care if it's identity theft, statute of limitations is gone, if you already beat the last debt collector in court, when they sued you, it doesn't matter, you still have to pay it. Well, that would be wrong. And I don't know that I've ever seen a debt collector do that, but things kind of come in waves. They'll stop doing things, and then years later they'll bring them back. So, it's good to have this in here. Number 13 is lying about the documents, saying that they are legal process. In other words, legal papers. So maybe you get a letter from a debt collector, and then you get a phone call from them, and they say, did you get that lawsuit that we served on you? And you're like, what lawsuit? I got a letter. Oh, that was a lawsuit, and you waited too long to respond, and now we're going to garnish your wages. Well, that would be a lie. Okay, it would get a lot of these other subsections here, but it certainly would get this subsection 13. Number 14 is when they lie about their name. Okay, now this gets a little complicated, if they have sort of a doing business as, but just understand if they're giving you a name different from their actual name, then it's worth checking that out to see if they violated subsection 14. Number 15, in a way, is kind of the opposite or the other side of the coin of 13. It says false representation or implication that documents are not legal process forms or do not require action by the consumer. So let's say you get sued and you call the collection law firm, or you call Midland Funding or Portfolio or whoever it is. You say, hey, I got these papers. What do I need to do with them? And they go, oh, don't worry about that. That isn't a lawsuit against you. You go, well, it sure looks like it's a lawsuit. It says in the District Court of Alabama or Circuit Court of Alabama or Small Claims Court of Alabama. They go, no, that's not. Well, if they lied to you, then they violated this section. Now, you will realize they've also violated a bunch of other sections here. But what if they say, yeah, that's a lawsuit, but you don't have to respond to it. As long as we're talking, you don't have to respond. Well, I guarantee you, on day 15, because you got 14 days to respond after you're served in small claims or district court in Alabama, and 30 days in circuit court. So once your time runs, in whatever state you're in, we'll have something, maybe similar or maybe different. But once that time runs, they're going to file for a default judgment and say, hey, we served them and they didn't respond. Well, if they lied to you and told you you don't have to take any action, then they got a real big problem with this. And then number 16 is the debt collector saying that they either operate or they're employed by a consumer reporting agency. So a consumer reporting agency, those are the credit bureaus, Equifax, Experian, TransUnion, Innovis, SageStream, those types of places. So if a debt collector ever says, well, we're calling you from Equifax or we work for Equifax, no, they're lying about that. So that's the end of section E, which is basically lying. A debt collector that's lying, that's being deceptive, misrepresenting things. And remember, there's an expression in the law and outside the law too, that a half-truth is oftentimes much more dangerous than a complete lie. Because a complete lie, we go, wait a minute, that's not right. But a half-truth that has just enough truth in it to make it really deceptive. So if a debt collector is just flat out lying to you, or they're partially lying to you, they're holding stuff back. Sometimes in the law we call this suppression. They suppress the information. They keep it hidden. So for example, we had a trial one time where we sued a debt collector. Debt collector called our client and said, we've got this credit card account now and you have to deal with us. She said, well, I don't want to deal with you. I want to deal with the original creditor, the credit card company. And they said, okay, that's fine. If you make this one payment, it'll go back to a credit card company, then you can get with them. And so she made the payment. And, truthfully, it did go back to the credit card company. And then about 48 hours, it bounced back to the collector. And we sued them for that. And they said, well, we told you the truth. It went to the collection or the original creditor, the credit card company, and then it popped back. We said, yeah, but you didn't tell us we only had 48 hours. And the jury found in our favor on that because they lied about it. They deceived us. And so all these illustrations, I think, what do we have? 16 subsections. Those are all just examples, illustrations of how debt collectors will lie. But they certainly are not limited to that. They will lie in all different ways. And so if you ever think you have a debt collector that's lying to you about something, it certainly is worth checking out. So thanks for watching this video. And in our next video, we will go to 1692F, which is really unfair conduct. And I think we can knock all that out in one video. And then we'll have one more really substantive section called section G. And then there's a few more after that that deal with some more kind of obscure stuff. And also, what do you do if they have broken the law? What can you get out of these guys? So it'll be, I think, interesting as we finish up this series. And appreciate you guys watching this video, and see you on the next video tomorrow. Thanks. Bye-bye.